Good morning and welcome to PV Legal's daily newsletter. The Supreme Court of India opened today's judgment with a line that sets the stage for everything that follows. Before any representative government can count votes, it must first know whose votes may be counted. That single sentence explains why the Bihar special intensive revision case matters and why the Supreme Court's ruling today will shape how India conducts its elections for years to come. The case is Association for Democratic Reforms and Others versus Election Commission of India, decided today. The bench comprised Chief Justice Surya Kant and Justice Joymalia Bagchi. A batch of writ petitions challenged the Election Commission's order dated June 24, 2025, directing a special intensive revision of electoral rolls in Bihar. This was the first such intensive exercise in that state since 2003, over 2 decades ago. The Election Commission won on every single issue. Bihar's electoral roll had not seen an intensive revision since 2003. 2 decades of summary revisions had accumulated. 7 lakh electors enrolled at multiple places, 22 lakh recorded as deceased, 36 lakh either permanently shifted or not found. The Election Commission treated the 2003 roll as the baseline and asked voters not on that roll to produce one of 11 prescribed documents. Nearly 65 lakh voters were left out of the draft roll for not submitting their enumeration forms. That is what triggered the legal battle. The petitioners, led by Kapil Sibal, Abhishek Manu Singhvi, and Prashant Bhushan, argued the exercise was unconstitutional, a de facto NRC, and an assault on the right to vote. The Supreme Court disagreed comprehensively. 4 questions were decided. First, does the Election Commission have power to run an SIR like this? Second, was the exercise proportionate? Third, did it comply with the Representation of the People Act and the Registration of Electors rules? And fourth, the most politically charged question, can the Election Commission examine citizenship status while revising electoral rolls? The answers came from Article 324, Article 327, Section 21, Subsection 3 of the Representation of the People Act 1950, Section 16 of the same Act, and Rule 21A of the 1960 rules. The court also relied heavily on the Constitution Bench's analysis in Mohinder Singh Gill, Sadiq Ali, and the demonetization case Vivek Narayan Sharma for the proportionality framework. On power, the court held that Article 324 is not a spent provision the moment Parliament legislates. It is plenary. Section 21, subsection 3 contains a deliberate non-obstant clause that frees the Commission from the ordinary revision process. It lets the Commission act in such manner as it may think fit. Even the word any in any constituency was held capable of meaning all constituencies where statewide problems warrant a statewide solution. On the famous Lal Babu Hussain presumption, the argument that voters already on the roll cannot be asked to reprove their credentials, the court drew a critical distinction. That presumption applies in individual disputes. An SIR is a systemic inquisitorial exercise. The court said it plainly. Calling upon electors to furnish supporting material during such an exercise does not negate the presumption. It is simply how the Commission verifies existing entries. And on citizenship, the court confirmed the ECI can examine citizenship questions, but only to decide electoral eligibility, not to make a final determination of citizenship. Removal from the voter list is not a citizenship verdict. The Commission must refer doubt cases to the central government's competent authority within 4 weeks, and that authority must decide before the next election. For voters in the 16 states entering Phase 3 of the SIR from May 30th, the ground rules are now legally settled. The Commission has a court-validated framework. The presumption attached to your roll entry is rebuttable, not absolute. If you are excluded, use the appellate mechanism. The court has confirmed it is meaningful. And if you are deleted on citizenship grounds, that is not the end of the road. The Citizenship Act proceeding is next. For the full legal analysis, read PV Legal's daily newsletter. This is your host, signing off for PV Legal's daily newsletter. Stay informed, stay vigilant.